morning, Your Honor. Your Honor, first thing I'll do is I'll formally adopt the very cogent arguments made by co-counsel in this case. And without tracking through those, but for Beth Brigmo giving birth to Roddy Bryan, God rest her soul, many years ago, but for that, Roddy Bryan wouldn't have been out there that day in his pickup truck. When we use this but-for causation, that there's a lot of baggage that comes along with that, and with all due respect to Ms. Dunikoski, it feels like they are stretching that term beyond recognition. The legal standard is proximate cause, and we'll come back to that in a moment, but when you look at it as proximate cause and not simply reducing it to two words but for, I think the court understands why the defendants are here making these motions. Your Honor, with respect to count one, malice murder, I'm really at a loss here to understand, but it was the state that decided to present what we sometimes call a kitchen sink indictment to the grand jury, where every defendant is charged in every possible way with every possible crime in this case. That was a decision the state made, and I certainly appreciate the challenge to the court in trying to assess these issues. As I look at the malice murder charge, there is no contention that Roddy Bryan shot anybody. There's no contention that Roddy Bryan tried to shoot anybody. There's no contention here that Mr. Bryan is acting as a principal. This is, if I misunderstood Ms. Dunikoski, I'm sure she'll correct me. The entire theory here is aiding and abetting, third section of that statute. And where is it that Mr. Bryan is intentionally aiding and abetting the shooting? Because he's not. Now, maybe some decision came out of the Supreme Court last week or last month that I'm unaware of. But when I went back through Kurtz last night, or it used to be called Kurtz, Offenses and Defenses in Georgia, and the section on parties to a crime, I know the court knows the treatise that I'm talking about. They list like 30 different ways that you can be a party to a crime, that you can be aiding and abetting in a murder case. But none of those are like the case before this court, which is why, although Ms. Dunikoski has cited this court well over 100 cases in oral argument, probably thousands of cases, and all the pleadings that have been filed and motions and responses going back and forth, Ms. Dunikoski cannot cite to you a single Georgia case that is remotely comparable to the one that we have before the court. This isn't the case where Mr. Bryan is driving down the street in his pickup truck and Travis McMichael is standing in the back of it shooting at Mr. Arbery. This isn't that case. There is no case, and she can cite no case remotely close to this one. The closest cases that I've been able to find, and of course they're referenced in there, in what I call the distraction aiding and abetting cases, in which one person intentionally distracts another person while someone else behind them either takes a knife and stabs them with it or shoots them. I call them distraction cases, where you're aiding and abetting by distracting. There is no evidence and no suggestion here that Mr. Bryan's conduct has somehow distracted Mr. Arbery. He's well aware of the pickup truck in front of him from the video. He's well aware from the video that they are both armed. So, and Mr. Arbery is not shot with his back turned. That might pose a different and a closer question for the court. But in this case, unless Ms. Dunikoski can cite some Georgia case suggesting this, which I still don't understand, theory of aiding and abetting the shooting of Mr. Arbery, there simply is no malice murder case here. And, co-counsel points out some pretty good cases on what the mens rea is required here. Where is any of that for Mr. Bryan? There's no malignant heart in this case. There's nothing from which that could be presumed. And, that takes us back to the whole concept of a citizen arrest. If I understand the state's theory here, the state contends that the McMichaels, and I believe they're contending that Mr. Bryan was assisting them or aiding them in attempting to make a citizen's arrest, which in the opinion of the state was not authorized under Georgia law. And that may be true, Your Honor. But the fact that Mr. Bryan aided and abetted a citizen arrest, if he did that, doesn't establish malice in this case. It doesn't establish an intent to aid and abet an intent for a shooting. You know, and Your Honor, I would urge the court to ponder the larger implications of the legal ruling that the state is requesting here. Because in this one case, it might serve the interests of the state. But in the larger question, if 10 police officers respond to a call, 10 police officers pull their cars up around a scene, and they're there, maybe they're still moving, Your Honor, and inexplicably, a police officer discharges his weapon and shoots the person that they're after in the head. Maybe they had probable cause, maybe they didn't. But are we going to try every police officer who's present at the scene of an attempted arrest for malice murder because somehow in aiding and abetting an attempt at an arrest, lawful or unlawful, that translates into aiding and abetting the shooting that follows? That can't be the law, Your Honor. And we shouldn't be creating special rules of law. There are enough of those. We shouldn't be creating any more special rules of law for one case, because we know the reality is that these things have unintended consequences and they take on a life of their own. We don't need to start down this theory that anybody who's attempting to arrest someone, which after the last legislative session is pretty much limited to police officers, that anytime police officers are attempting to arrest somebody, particularly if they're attempting to do so unlawfully, that they're aiding and abetting the arrest, lawful or unlawful, is aiding and abetting a shooting or other unlawful use of force that follows. There is no malice murder case as to Mr. Bryan. There is no authority for this case. Your Honor, the state wants to talk about but for. I want to talk about intervening factors. And before I do that, Your Honor, I would, maybe it's just me. Maybe I'm just not smart enough to keep up this Dunikowski here, but the way Ms. Dunikowski is presenting this malice murder argument to the court is, in essence, collapsing malice murder into felony murder. What distinction is left here between malice murder and felony murder when Ms. Dunikowski makes these arguments? Because it's winding up being the same thing. Well, you know, he intended to shoot, therefore he intended to kill. Or he intended to falsely imprison, he must intend to shoot. How do we distinguish at the end of the day with the arguments made by the state between malice murder and felony murder? Your Honor, this is a case, and this feeds into the severance issue. And with all due respect to Ms. Dunikowski, I would humbly suggest to the court that if Ms. Dunikowski continues to proceed along this line with malice murder, and we go into the defense case here, we are going to have, at some point, antagonistic defenses that cannot be overlooked. The state, as I understand it, has not submitted a charge on manslaughter. My understanding that learned co-counsel for the McMichael defendants has not submitted a jury charge on manslaughter. And part of that, I think, well, there's different strategic reasons why people do things, but my point to Your Honor is, in terms of proximate cause, do we not have not one, but two intervening factors here? Factors that are not reasonably foreseeable to Roddy Bryan. Maybe logically foreseeable in something that's conceptually possible, but not reasonably foreseeable in the sense that the law would imply. You have in the video, and unless I missed it, this part of the video the state contends is undisputed, uncontradicted. In the video, at the last minute, you see Mr. Arbery, instead of turning right towards the exit of Satilla Shores, he turns to the left. Now, it's not for me to judge or question why Mr. Arbery does the things he does, but when he turns left instead of right, regardless of his justifications or his reasons for doing so, that is an intervening cause, an intervening circumstance, I submit, under Georgia law. And at that point, it's not foreseeable to Mr. Bryan. It's not foreseeable that just like on the street with the police officers, suicide by cop is not reasonably foreseeable, nor is suicide by citizen's arrest. When Mr. Arbery turns towards Mr. McMichael, that is an intervening circumstance that breaks any causative chain here with respect to the shooting and death itself. Likewise, And I'm certainly not taking sides in this. It'll be for the jury and the court to determine the guilt or innocence of the McMichael defendants. But at the same time, you have a second intervening factor. The first intervening factor is Mr. Arbery pivoting to the left instead of heading for the exit. The second intervening factor is Travis McMichael discharging his weapon. And I'm not questioning why Mr. Arbery is doing what he's doing. I'm not questioning why Travis McMichael is doing what he's doing. But what I'm saying is you have a second intervening factor, which is the choice of Travis McMichael to discharge his weapon. It doesn't really matter for purposes of evaluating count one malice murder if the court can see that whoever's in the right here, whoever's in the wrong, whichever party is using excessive force, maybe both parties are using excessive force, maybe there's some kind of mutual combat theory to be had out there. But from Mr. Bryan's perspective, in terms of proximate cause, in terms of what's reasonably foreseeable to him, none of these things are reasonably foreseeable. And I think the court understands the consequences if the court were to go down any other road. And if we're going to persist with this issue, we're going to wind up in a severance posture. It may be premature. We haven't heard whether any of the other defendants have testified yet. But I would submit the easiest way to resolve the severance issue is to grant the motion for directed verdict for Mr. Bryan as to malice murder. Moving on to count 2, felony murder, which is tied to count 6, aggravated assault to a shotgun. Again, the arguments come down very much the same way, because the state's position on malice murder is essentially, although not in so many words, collapsing into felony murder. Where is the intent on the part of Mr. Bryan to facilitate an aggravated assault with a shotgun? Again, it's one thing to say, if the state contends that's what the evidence shows, that Mr. Bryan is attempting to assist in a citizen's arrest, aiding and abetting a citizen's arrest. But there's nothing reasonably foreseeable about killing someone in a citizen arrest, just as on the street, there's nothing reasonably foreseeable to police officers when a fellow officer, without cause, discharges a weapon, in these days maybe even a taser, and kills somebody. Again, there is no proximate cause, and there is no mens rea, there is no aiding and abetting the shooting. Now, Ms. Dunikowski wants to make a big deal of the fact that the gun is visible, that Mr. Bryan's truck is still moving, although obviously at a slow rate of speed, and therefore because he doesn't run in a ditch or he doesn't back up, that he somehow is now joining in the shooting. But again, I understand that the state's position is pretty clear, almost uncontradicted, that this is a purported attempted citizen arrest. Again, in the context of a citizen arrest, is the fact that Mr. Bryan is maneuvering his truck, and positioning his cell phone to follow Mr. Arbery and document what Mr. Arbery is doing. How does that circumstance, whether he's traveling at 2 miles an hour, 4 miles an hour, or 6, how does that establish his aiding and abetting the shooting itself? Because Mr. Bryan only has knowledge of the existence of the weapon, as we see on the video, at the very last moment. And still, at that time, from Mr. Bryan's perspective, even if he's attempting to aid and abet a citizen arrest, that's not the same thing as aiding and abetting a murder. I mean, would it be it's the same thing, Your Honor, whether Travis McMichael is shooting him or not, or whether he's pulling out a club and beating him on the side of the road with a billy club like a police officer would do. Again, how is Mr. Bryan's assisting, if that's what it is, in a citizen arrest, showing that he's attempting to aid and abet the shooting, aiding and abet an unlawful, excessive use of force in the making of an arrest? That's just not there. That's just not Georgia law. And again, the state says the jury should consider the fact that they had their guns drawn. Okay, well, how is Mr. Bryan, again, to know that they have any intent in drawing a weapon, whether it's in the down position, the up position? I'm not a use of force expert, but whatever position. Again, how is that telling Mr. Bryan that they intend to use excessive force, that they intend to kill him, that they're not trying? Maybe that's the state's theory, that they weren't really trying to make an unlawful arrest. They were just looking for an excuse to kill him. or they were just waiting for the opportunity, notwithstanding the fact that they've had lots of opportunities to shoot this gentleman over 5 minutes. He's clearly, in terms of proximate cause, when you look at the video, you see Mr. Arbery. He's well within range. He's well within shotgun range. He's also well within range of Travis McMichael's handgun at the time that Mr. Bryan is pulling up. From Mr. Bryan's perspective, he didn't have any reason to think they were trying or intended to hurt these people. They had ample opportunity to do that long before he got there, long before he pulled up. Again, I'm asking the court to grant a directed verdict on count 2, felony murder based on the underlying count 6 aggravated assault with a shotgun.